So, Asha, how bad were these Supreme Court decisions anyway?
Eh, it's complicated. I'm Asha Rangappa. I teach national security law at Yale University and a legal contributor for ABC News.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down to a soundbite or a tweet.
So, Asha, we had a lot of Supreme Court decisions that came out at the very end. They were not surprises, I think, to most of us who were paying attention, but they were very consequential. And thankfully for me, you've already spent a lot of time explaining these on ABC News, so you can be the bear the burden of walking us through some of these decisions. I mean, I think the first one, I mean, maybe to start on a happy note, was Moore versus Harper, right? That was pretty consequential, but in a very good way.
Yeah. So I was basically strapped to my dining room chair last week, like on Tuesday and Thursday and Friday. Felt like a soccer goalie, waiting for which opinion was going to come down. But we knew these big ones were left. They saved them till the end. And yes, so the first one, let's take some time just to walk through these so that people understand what the issue was and what the court said. And then we can turn to why it's important and why it matters and what happens. All right. So Moore versus Harper was the long-awaited decision on the so-called independent state legislature theory, ISL. So, and jump in, Renato, because, I was covering a lot of different stuff. So if you have clarifications, please let me know. So the independent state legislature theory is based on the idea that the federal constitution gives state legislatures the power to determine the time, place, and manner of elections.
Right. So the important context is the federal government does not run elections under the U.S. Constitution. They're run by states. Traditionally, that clause was interpreted to give that power to state governments. That's different than state legislatures, because what it means is, for example, that state legislature would ultimately be subject to state law. The state Supreme Court would be able to regulate how state legislatures exercise that power and so on.
Right. So, but the federal constitution says state legislatures. And so the independent state legislature theory is that legislatures and only legislatures have the power to make all the rules concerning elections, and they can't be constrained in any other way, including by the constitution of that state. Essentially that courts cannot review what they do, even if what the legislature does violates the law of the state. It's basically like absolute power, or that, for example, even the governor could not veto something that the state legislature determines with regard to. So it's basically like in this area, the state legislature is all powerful. It's a pretty extreme theory. And in the next segment, we'll get into the implications of it. But that's what was up in front of the court.
Right. I mean, and just that would mean, for example, I would believe a state law that determined how electors are apportioned. That said, for example, you have to have your state's electors go to the winner of the popular vote in that state. A state legislature could decide they want to go in a different direction.
Right. So in this case, this involved a North Carolina partisan gerrymander. And the state Supreme Court, which at the time had a Democratic majority, so remember that at least in North Carolina, the state Supreme Court justices are elected, said that this gerrymander violated the state constitution, which guarantees free and fair elections. In other words, the state constitution has a provision, that a free and fair election provision, and they felt that this partisan gerrymander violated that. It was at that point where it goes up to the Supreme Court. Then the composition of the state Supreme Court changes, and it becomes a Republican majority, and they reheard the case and threw out the old decision. And this becomes important for, I think, the dissent. So anyway, back at the ranch, basically what the Supreme Court says, and this, I believe, I don't have this right in front of me, but I believe it's Chief Justice Roberts writing this opinion, who says that, no, sorry, state legislatures are subject to judicial review. And so they basically say that when the framers wrote the Constitution, they understood the concept of checks and balances. These were operating in the states. This is really giving the power to state governments. In other words, it's giving power to the legislature to the extent that it has power under its own Constitution. And the quote here is, when state legislatures make laws, they are bound by the provisions of the very document that gives them life. And so it's a pretty, it was a good little bench slap on this independent state legislature theory. It reinforces this very basic principle of judicial review and the idea that there are checks and balances, and it's the role of a court, even a state court, to say what the law is. There is a little sliver in there where they're distinguishing Bush v. Gore by basically saying that state Supreme Court decisions can be reviewed by federal courts, and that if the state Supreme Court's interpretation of its own Constitution is just so far outside of the bounds of reasonable interpretation, then a federal court can step in and check that. But that's not what was happening in this case. And then the dissent, I believe this is Thomas, is basically says, look, he claims that this issue was moot, that the court should not have actually been deciding this because, as I mentioned before, that underlying court decision had been thrown out by the new state Supreme Court that had reheard the case.
Yeah, so the issue of mootness, there's a number of different doctrines that limit when a federal court can examine an issue. Mootness is one of them. In other words, if something's moot, in other words, if the decision doesn't matter anymore, a court will typically not decide that issue because it's no longer a case or controversy. In other words, courts are not supposed to give sort of advisory opinions. It's fair to say that mootness is something that's brought up usually. The courts exercise it when they want to, and others they have discretion to do so. And it's there's a lot of debate about when courts are exercising that discretion to, or that they find that a case is moot. Let's just put it that way. One thing that I just want to make sure is clear is, before we move on, is just, I had said earlier, I said, traditionally this has been interpreted as you reiterated, to be the state, the entire state having that power, not the state, the state legislature. And so people might be like, well, then why even have this? Why did this change? I would think it's fair to say there was a movement in a conservative movement, Federal Society movement. This is like a kind of a new theory. And this bubbled up to the Supreme Court. And I think it's fair to say that this was an example of how, even though you have a 6-3 conservative or right wing, whatever you want to describe it, majority in the court, that doesn't necessarily mean that every theory coming out of the Federal Society gets rubber stamped.
Right. And I think, this Moore versus Harper was also coming on the heels of a couple of other cases, like the challenge to Section 2 of the Voting Rights Act and the Indian Child Welfare Law of 1978, both of which were trying to kind of upend decades of jurisprudence and the way that these, laws had been understood. And the court did not go in the direction that I think in the direction of being challenged and kind of upending everything. However, that all changed on Thursday.
Indeed.
Yeah. So the next case was this was Students for Fair Admission versus Harvard, and then also UNC. So these were a pair of cases that were basically challenging affirmative action policies in each of those schools. And the reason that you had two schools involved was that one is a state school, so it is subject to the 14th Amendment, Equal Protection Clause, and then Harvard, as a private institution that receives federal funds, is subject to federal legislation under Title VI of the Civil Rights Act, which incorporates equal protection principles.
Yeah, just so everyone who's listening understands, when the government deprives you of something, you have greater due process protections and equal protections because that's the state, that's the government acting versus just some private organization.
Okay, the question is whether these schools can use race as part of an effort to create a diverse student body. And this is going back to several cases in the past. There's a case called Grutter versus Bollinger in 2003, which basically says, yes, race can be one factor considered among many in order to create a diverse incoming class. And interestingly, in that opinion, which was written by Justice O'Connor, and again, this is in 2003, she says something to the effect of, this won't be necessary 25 years from now, because essentially we will have corrected, or we will have kind of created maybe some momentum or whatever. What Harvard and UNC were describing is that they would be considering their admissions, doing these holistic reviews. And I think one important piece here is that they would periodically check the overall composition of the class, the overall racial diversity of the class. And the court here says that as practiced by UNC and Harvard, that their actions violated the Equal Protection Clause. And when a court is looking at an equal protection claim based on racial classifications, which this was, they use a test called strict scrutiny. And there's a number of tests that determine whether, different classifications are permissible. Strict scrutiny is the highest standard, and the government has a very high burden here. And what the government has to show is that the policy that is being used is narrowly tailored to fulfill a compelling government interest. And basically what the court here says that it does not, that the way that this was being practiced at these schools doesn't survive this test. And there's a number of reasons why. One is that the compelling interest itself of diversity, the court says it's not measurable. Like, we can't really determine when that goal is achieved. And, quotes this old case, Grutter, and says, this was supposed to end, but it doesn't seem there's any end in sight because, there's really no way of knowing like when that goal has been achieved. And then also finds that this isn't really narrowly tailored. The connection between the means and the ends don't seem to fit. And they see admissions as a zero-sum game. So if you're, considering race for some people, then, as a benefit, then necessarily other people are kind of getting kicked out as a result. And so basically this type of affirmative action, which I think is really about using, the way I understood this was using race per se someone's, self-identification of race as as diversity itself. The checkbox, the oral argument is really focused on, are you looking at the checkbox or are you looking at the person? An important caveat here, which we can unpack in a bit, is that they don't say the consideration of race is categorically impermissible. So what Robert says is, if someone discusses their race and how it impacted them and their experiences and their perspective, you can consider that as a part of, their candidacy and whether you want to admit them. But you have to do that at an individualized, particularized basis. Simply the fact that they are of a particular race cannot be enough. And so I think this idea of diversity in the aggregate, what they're really, I think, undercutting and dismissing is that race can be a proxy for lived experience. And this is the big, I think, disagreement they have with the dissent, which really undercuts the idea of structural racism, right? Like that some people are inherently experience the world differently because of structural disadvantages. And then the second thing I think that they are dismissing is this idea that there is an inherent diversity interest in representation. Where you have like a critical mass of a certain group, and that in and of itself is a part of diversity, though I don't think that these schools argued that. I don't think they were making that claim, which I find puzzling, or at least the opinion says that they did not make that claim. So Justice Sotomayor, Justice Jackson also have dissenting opinions, and they basically say this is this idea that we're a colorblind society is simply not true. And what you're doing is undermining the fact that people have different lived experiences by virtue of their race. I think this is the fundamental disagreement.
Yeah, I mean, I will say with this case, I mean, I'm pretty familiar with it. My co-clerk was the lead trial lawyer for this in this case on the right wing side of it. So I'm very familiar with the facts of it. One thing I would just say is that the way in which Harvard put its affirmative action program into practice was not ideal. They created a lot of bad facts for themselves.
Yeah, the LOP list.
Yeah, you want to. Yes, I mean that's one example.
The LOP list. This is what I mean about that. Looking at the overall racial composition. So it looks like what they would do is go through and essentially determine whether someone was a presumptive admit or not. And when they go through and they finally get to their final pool, they have more presumptive admits than they can actually make offers to. And so what they would do at this stage is create a LOP list where they determine who's going to get lopped off. And I think the LOP list was turned on things like legacy status, athletics, whether maybe they're getting a point, extra weight for athletics. I feel like there was something else, and then also race.
It was just they numerically quantified race. They turned every candidate, and I understand they get a lot of applicants, but they turned every candidate to a number, and they just assigned race a number effectively throughout the. So when I read about all of this as it was happening and heard about it as it was happening, I was like, wow. You could imagine a decision. Let's just say that you had 6-3 progressive majority. You could imagine a decision that said, well, affirmative action's fantastic, but the way it's implemented here is not appropriate. So I think that I will just say the reason I'm bringing that up is because they say bad facts make bad law, and I do that's that old saying. I do think that had something to do with this decision, but it's fair to say I agree with you that it went much further than that. Although I think, and we can talk about this in the next segment, I think there's a room for disagreement about necessarily how far the opinion goes.
I agree.
Yeah.
So let's turn to 303 creative So this is a case challenging Colorado's public accommodation law. Public accommodations laws, which many states have, basically says that businesses have to serve everyone. That if you offer up a service, you can't discriminate against who you provide that service to. So restaurants can't kick people out because they just don't, whatever, because of
They don't serve black
because you're
people
black
or
people,
something.
right? Exactly. I mean, this actually comes from things that have happened, right? So
yes, lived experience. Yes.
So Colorado has this anti-discrimination law. A website designer, and we'll get into more of the facts a little bit later, brought a claim saying that she wanted to start a wedding website design business, but she did not want to design websites that promoted same-sex marriage. And this public accommodation law would effectively compel her to do that because she would be forced to serve anyone who asked her, and that this was a violation of her First Amendment right. We'll get to the standing issue in a second, but basically the question is this law essentially compelling speech? So the federal government, the government under the First Amendment, they can't, censor you, they can't issue prior restraint, but they can't also force you to say things that you don't want to say, right? So this is the free speech also, has all of these facets. And what she's saying is this is a form of compelled speech, and the court agrees with her that if this law is enforced, yes, she would have to essentially create a message with which she doesn't agree, and that what they're saying is this isn't really based on who's asking her to do this service. It's based on the message that she's being asked to express. And because this business has this creative, expressive component, she does have a First Amendment interest in this. It was a really weird framing because, and Justice Kagan, who issues the dissent, basically calls them out and says, this is a kind of a new way of approaching these public accommodation laws, because normally when you look at whether a law is infringing on speech, you look at what the law is doing on its face and what the intent is, right? And what she says is this law is regulating conduct. It's trying to proscribe the act of discrimination. It has nothing to do with speech. There's nothing in it about forcing people to make a message. And I think, she goes into this idea that, no one has to provide a message or not. It's just that if they decide to provide a message of one kind or another, like they just have to they have to allow everyone to utilize it.
Yeah, I guess so my understanding, this was not a facial challenge, right? This was as applied to her.
Yes, but it's weird because, it's weird because, and I got to thinking about this because Justice Kagan mentions this, and I was at Yale Law School when this was going down. In the mid-2000s, before the Don't Ask, Don't Tell policy in the military was repealed, which is hard to believe that wasn't that long ago, military recruiters would come to the law school and other law schools to recruit for JAG. And many law schools, most law schools, have an anti-discrimination policy. In other words, they will not discriminate on the basis of, race, sex, national origin, and they're not going to facilitate that in any way. And so what they did was they said, listen, because of our anti-discrimination policies, we can't allow military recruiters to recruit on campus. And they said, just like if there was some employer who didn't want to hire women or didn't want to hire, Asians, like we wouldn't allow them, we wouldn't include them in our process. Then Congress passed a law, an amendment to maybe the Higher Education Act or something. It's called the Solomon Amendment. And the Solomon Amendment said any school that takes federal funds has to allow military recruiters access to all of the same resources that they provide for other employers. And the law schools sued and said, this is a violation of our free speech, because what you're asking us to do is to promote, these organizations, tell students about it, give them all of the same support and platforming and promotion that we do for these others in violation of our stated policy. And what the court says in that case is it was not a violation of the First Amendment because all the law was doing was ensuring equal access to the military, and any burden on the speech was only incidental. In other words, that was not the purpose of the law. So that's, I think, the big beef that Kagan has, and why I think it's an interesting counterpoint that in this case, they're really looking at the impact on the individual as opposed to what the government's purpose and intent was.
Yeah, I mean, a couple of thoughts on this, just from an explanatory perspective before we get to consequences. One thing I want to make sure everybody understands is this is a First Amendment case. It's a free speech case. At least that's how it's framed. That drives a lot of this. That's why you're seeing the results here. But the framing in a First Amendment case matters a lot in terms of how the court looks at it. And so one thing that's the case is expressive conduct. And it could be something like making a cake. It could be something like, one thing that's always been controversial in the law is like, strip clubs, that's considered, dancing is considered, First Amendment expressive activity. There are lots of controversial decisions where it's like, well, if the Supreme Court's view is, hey, if you have expressive activity, you need to have the right to be able to express it however and not be compelled, et cetera. Yale Law School, let's just say, to use your example, would say, well, hey, at our Yale Law School event, having people who are discriminating there suggests that it's forcing us to promote this activity. And I think the framing there by the court is like, well, you're just effectively a forum that is providing access to people to this forum. It's like the way that, let's say, Twitter is not endorsing every view that's on it, or your local shopping mall is not endorsing the view of everyone who's handing out placards outside. And so it's purely the way in which you look at it. But that, I think, is the distinction. The court, just from an explanatory perspective, without getting to consequences, that's, I think, how I would explain that distinction.
Yes, exactly. I think this was a dispute about how to frame this controversy. And the majority is saying this is about pure speech. This is about this person engaging in, expression and speech. And Kagan is saying, no, this is about conduct, not speech. And I think that's the fundamental distinction. Of course, Kagan loses. So we'll get back to the implications of looking at when businesses are engaged in expressive conduct. Okay, so finally, the last one was Biden versus Nebraska. This was on debt relief. There was a companion case that was brought also on the student loan program by two individuals who basically claimed that they had been injured because they couldn't benefit from it, and those got thrown out on the grounds of standing.
Right. And just so everyone understands what standing is, that's another one of these doctrines like mootness. It limits what courts can do. So you need to be somebody who actually has been injured in some way or impacted directly by something in order to bring a lawsuit.
Yeah, and we'll come back to that issue on the LGBT case. So Biden versus Nebraska involved 6 states challenging the debt relief plan issued by the Secretary of Education. Loan repayments, once COVID hit, had been put on hold, and this was under the Trump administration. But what the Biden administration did was, and that was done under something called the HEROES Act. The HEROES Act essentially allows the Secretary of Education to respond to a national emergency so borrowers are not worse off and it was passed after 9/11. And the specific language authorizes the Secretary of Education to waive or modify existing loan provisions. So Biden used the authority under the HEROES Act to essentially forgive up to through the Secretary of Education to forgive up to $20,000 of loans, and subject to whatever different eligibility requirements. MOHELA, which is the Missouri Higher Ed Loan Authority, which services loans across the country, was not a party to this suit, but the state of Missouri was essentially bringing suit on MOHELA's behalf. So there's a whole standing issue that came up here also, whether a state can use this private entity and, bring a suit on their behalf. The court says, yes, this is an instrumentality of the state, and basically the state can kind of stand in and bring this lawsuit. The total price tag for the Biden loan forgiveness program was $400 billion. And so the court says so this is what's called a delegation of authority by Congress to the executive branch. And the idea, Congress delegates authority all the time because they can't be legislating every single law, and especially in a national emergency where things might be changing and you might need, to act quickly. You can delegate authority to the president to act and respond in certain ways. And what the court says is, yes, the HEROES Act delegates authority to the Secretary of Education to waive or modify existing provisions, but this loan forgiveness scheme, which is going to essentially cost the government $400 billion, goes way beyond waiving and modifying. That this essentially creates a fundamentally new program outside of the statutory scheme contemplated by Congress. Essentially, they're saying that Biden was creating law. And as a separation of powers issue, this is something that Congress would need to do, that even, this is an appropriations issue, that this really belongs in the House and Senate Appropriations Committee. So it's a separation of powers argument. And what they are looking at is the magnitude of what Biden was trying to do, that, they invoke something called the major questions doctrine, that this is a decision that has vast economic and political significance, and that it's just so big that it's beyond the scope of what Biden had the power to do.
We'll get to the implications later, but I think that adequately explains it. I mean, I'm sure one question that's going to come to our listeners is, well, why is this different than, let's say, Trump with immigration or other things, right? That where the federal government is, the executive is making decisions, right, about the border wall or something like that.
Yeah, and it's a great example. If you'll recall, I forget what year it was. Was it 2019, where Congress did not appropriate money to build the wall, and Trump utilized authority that was given to him to act in a national emergency, where he could reallocate certain military funds. And he basically declared a national emergency because of, the invasion at the border or something, and essentially reallocated money towards building the wall. And the question there was similar. I would say in that case, it was even more of a direct, end run around Congress saying no, because there was an explicit rejection of his wall in their appropriations bill. But it's this tension of delegating authority, and then, the president, the president has the authority to determine when a national emergency exists, and how to respond. How far can he take some of these delegated powers, and what's the right balance? In that case, I think there was in the legal world, a lot of debate on whether has Congress delegated too much authority to the president? In these ways that we can see how it could be abused. In addition to whether he had misinterpreted or he had gone too far.
Yeah. So let's maybe discuss all of this in a moment and talk about the implications of all these decisions, because there's a lot to discuss. So, Asha, what do we want to talk about first? Yeah, there's a lot there.
There's a lot there. Let's just go back to the beginning and go in order. The independent state legislature theory, that was a big sigh of relief, I think. As you noted, this is a conservative legal theory that has come up because essentially, to the extent that you are trying to create election rules that allow you to win, it's much easier to do that if you have Republican-controlled legislatures that don't have that aren't accountable to the state courts or even to their state constitutions. And maybe you can talk about how this relates to the John Eastman plan and January 6th. That's something that under the independent state legislature theory, which I believe that John Eastman had actually articulated in his quote unquote legal memo, would allow something like states to just submit an alternate slate of electors if they didn't like how an election turned out.
Right. So just to be clear, the fact that Moore versus Harper was decided this way doesn't mean that shenanigans cannot occur in presidential elections. And if they had decided it the wrong way, it wouldn't necessarily mean that the next election would be overturned, but it would make it more likely, make it easier to do that. And the part of the reason why is because, as you just did an excellent job of explaining, Asha, earlier, state governments run elections, but so they have a lot of control over how, for example, their electors are apportioned. And ultimately in the United States, our votes, my vote, Asha's vote, your vote does not determine who becomes the president. It's ultimately the votes of electors. And how those electors are selected depends in part on state law. Now, the fact of the matter is, in most states, the vast majority of states, there are actual state laws that restrict who can be an elector to, the representatives that are that represent the candidate that won the majority of the popular vote in that state. And so, if a state legislature could ignore state law and just vote for whatever they wanted to vote for, the same people who were voting to disenfranchise their own members in Tennessee, for example, or wherever, could just be like, you know what, let's just make Trump just give all of our electoral votes to Trump. You can imagine in Georgia or Arizona or Michigan or someplace like that happening. And so this was very consequential for the preservation of American democracy. And I think the real question is sort of, it's sad that we even thought that was possible, but it's a good thing that the decision went the way it did.
Yeah. And just P.S. Ginny Thomas is a huge independent state legislature theory proponent. And it's hard,
She never discusses that with her husband, ever.
She never discusses that with her husband. I'm sure that had nothing to do with the fact that he did not agree with taking a position on it right now.
There you go. Indeed. Yes. He dissented on mootness, right? So yeah. Okay.
Yes.
Mm-hmm. So how these things go. You
conveniently
you kick it down the road for another day, right?
Mm-hmm. For another election, maybe. And by the way, can I just say that having it undecided, in other words, if Thomas had his way, you can imagine if states in some coordinated fashion, Republican legislatures did try to, in 2024, submit fake slates, and then there's either a question about who really won the at that point, it's much harder for the court to then arbitrate that. In other words, to undo expectations or some sense that Trump really won the election again. This is something that really needed to be clarified now. And so the idea of kicking it down the road is in itself, I think, deeply troubling.
That's interesting. It's a very interesting comment. I hadn't considered that, Asha. So what Asha, just to unpack what you said, your point is that it's much easier to make that decision when there's nothing at stake, really.
Mm-hmm.
Okay. Versus making that decision when the presidency is at stake, Bush versus Gore or whatever, or, Trump versus Biden, where it's like everything is at stake, depending on how we answer this question. I agree with that. That was why, in the last segment, I kind of talked about mootness. I'll throw standing, ripeness. There's all sorts of these doctrines that are used by courts to as reasons not to make decisions. Generally speaking, my general take is judges should do less, not more, in it's a general matter. And so I generally support, the things that restrict judicial authority. But in this case, I think you're right that an argument can be made that it was very important not to have uncertainty in the law, because now this decision is going to cut out at the knees a lot of efforts to engage in shenanigans, to use the word I used, in the upcoming election.
Yeah, at least to engage in a certain number of shenanigans.
Certain type of them.
Mm-hmm.
As I said, they still can happen. That's why I put that disclaimer in the front end. Like, there still could be shenanigans. Yes.
Yeah. And I think the facts of this case actually illustrate, you had a partisan gerrymander, and as soon as a Republican dominated court assumes the bench, they are fine with it. That can still happen.
Right.
But I do think that, you want to have the idea of actual judicial review to still be a thing in a democracy.
Yes, indeed. 100%.
Okay. So the affirmative action case, I wrote a Twitter thread where, because I think I was seeing chyrons and pundits, saying affirmative action is dead. The court bars race-conscious admissions. And I didn't think that was entirely accurate. And I have to say, I was looking for, what I expected was, or what I was not expecting necessarily, but looking to see how far they were going to go. And you can imagine a court that said, you cannot consider race at all. You can't talk about it. You can't think about it. It can't be a factor in making a decision at all. And you can imagine that would have shaped the admissions process in a very particular way. Like, you would have to not have it, you'd have to basically instruct applicants that they could not discuss it. Even if it was fundamental to their identity, you'd have this, completely blank slate and all other, qualities that they can talk about, but they cannot talk about that. So, and I think there's some disagreement, but I think it's actually notable that students can talk about their individual experience. And my prediction is that you're going to see, this is there anyway, but there, more diversity essays, as supplemental essays. And I think that really the upshot is it's just going to take longer for admissions offices to review applications, because they're going to have to really drill down person by person. They aren't going to be able to zoom back and see how the class looks, which means that that's going to be harder for schools to really look at that bigger diversity picture. If you have a school that's that has 10,000 people, it just becomes, hard to know what you're admitting. But it does mean that it's like race is not completely off the table. I don't interpret this decision as barring race-conscious admissions. It bars race-conscious admissions in a particular way that allowed race to be used as a proxy for diversity, race to be used as a proxy for diversity, which, incentivized schools to design their processes in a particular way, and they're going to have to now redo it.
Yeah, I mean, so it's interesting. I did not read your thread probably because I couldn't read anything on Twitter this week. I mean, I got so fed up with all of the BS throttling or whatever. I just gave up on Twitter this week. I didn't tweet a lot this week or try to retweets because I couldn't read anything for much of the week. But it's not surprising me that you and I ended up at a similar spot. I thought I was going to have some super hot take, but it's not all that different than yours, which is, I don't think this decision is nearly as consequential as people think it is. I think it's driven by some of the really bad facts in this case. And I actually think it is kind of sloppy if you care about diversity to basically try to make it so your percentage of X group is exactly the same every year. I mean, maybe presumably you're going to get all different applicants every year. Maybe your percentage of, whatever, Latinos is going to be X one year and Y another year, and it's going to fluctuate up and down depending on the quality of the applicants in that particular pool. But the fact that there was an element which it looked a little sus, the way that they were doing it was a little ham-handed. And what the process you're describing is a way in which many businesses now engage in affirmative action. I mean, when my law firm makes hiring decisions for partners, we consider a person's experience, and we consider the message that's going to send to ourselves and our client base. It's it's not a numerical decision where we're like, okay, we are giving this candidate 47 additional points because she's transgender, but she'd get another 13 points if she was disabled or something. Like, I think it's possible to make individualized decisions that take these things into account. It's going to, like you said, be more complicated and expensive for admissions departments. So it will be more challenging for them to do, but Harvard certainly has the money to do that. I think that they could just, like you said, have essays are explicitly noted in the opinion, and Harvard made a statement after the decision, like calling out Robert's statement about that and saying that that's what they're going to do. And I just think if they do that, I don't know how much different the outcome is going to be other than, I mean, maybe to some extent, but it may be whether it's better or worse. I don't know.
Yeah. I think there's two big things. One is that it does take out this idea of representation as an important element of diversity. I do think that is implicit there, and it's an important one because, the idea is, Renato, your firm's partnership could include, many different people who all contribute to, different elements of diversity. The question is, is there also a separate interest in having a certain, representation of women as partners or underrepresented minorities as partners? And I mean,
Right.
that's a policy question, but I think that's the one that the Supreme Court is really saying no. That's not. We don't consider that the aggregate, the representation, the reflection of some kind of the student body as being, mirroring in some way the applicant pool or maybe even the society at large as being an important interest.
Isn't that, I mean, as a practical term, I mean, you're right that I think implicitly in the language of the decision, there's a rejection of that approach. But in terms of what the decision outlaws, if it's in fact the case that Harvard is going to have the same view that that it's important for them to have a certain representation of, let's say, Black people, of Latinos, of transgender Americans, of whatever, all these different groups, and all that's going to mean in a practical sense is, instead of quantifying it, they're just going to look and they're going to make, wow, Jane is got this amazing experience as somebody who's been discriminated against as an LGBTQ American. We really like her, as opposed to saying that she's going to get some extra points. And
yeah, absolutely. Practically speaking, like I said, I think it's going to increase the time and resources needed to go through the admissions process. And I think, importantly, this shifts the burden of having to really articulate, your own, like, the impact of your racial identity in a very explicit way, which, in some ways I think might cut against this idea that we should be colorblind, because it's really asking students to package themselves in ways or kind of think about their experience only through this lens in a way that maybe ordinarily they might not have. Maybe that also means that they aren't contributing to diversity. I don't know. But my point is that it is burden shifting a little bit in terms of making the case for why you add to diversity. And I also think, importantly, this is the other thing that I mentioned in my thread, the very fact that this will end up being more explicitly articulated, and that schools will be doing this on a very case-by-case, like almost even more holistically, right? Like they have to look at it and they're going to determine like this whole package, like in this person's experience. I actually think it's going to be harder to challenge.
Agreed.
Like, in other words, if schools like overcorrect or decide that, okay, we really care about, people's experiences with discrimination, and you suddenly see the numbers shoot up, I think that it will be crazy for the anti-affirmative action people will go bonkers. But then what is their recourse if Harvard says, well, I don't know, we read every single application and this is what we decided was important.
Yeah, that's the thing. And not to spend too long in this, I know we have a couple other cases to discuss, but my reaction to this as a litigator was like, man, you've already had multiple challenges to affirmative action. Like, why you would have chosen the approach they did is bizarre to me. Like, yeah, as a litigator, I'd be like, choose this. I assume they already were doing what they're required by this decision because it's so much harder to challenge. And it's just, it is what it is. I mean, I think that's so many companies make decisions now. They take into account, they'll explicitly say, we are taking into account diversity. We want to have a diverse workforce. And then they'll just make an individualized decision. And what do you do about it? I mean, they could see the person's photo. They could see what the person's saying about themselves, and they're going to take that into account. And they're just, at the end of the day, they can characterize that however they want when a deposition comes.
Yeah. So we'll see. I mean, I think you're going to see more litigation, but, we'll see how it turns out. Okay. 303 Creative. So there were two issues here. Number one, as I mentioned in the explanation, and this was known to the court, that this is a pre-enforcement action. This is a woman whose business had not even started. Like, she had not actually created the business. She was thinking about creating a wedding website business, and she was worried that this law would be enforced against her, which I think already creates some standing issues. And maybe you have some thoughts on that. But the second issue is that in the last week, or not even last week, last 5 days, it's come out that, her worry was generated by an email she got from a person who said that they wanted her to create a website for his same-sex marriage. And now it looks like that email may have been fraudulent because the person who sent the email, they actually tracked him down. He's like, no, I never sent that email. So unclear. And so I don't know. I don't know if her state of mind, if as long as she thought it was real, whether, that's what matters. But even so, I think there's a question of whether the fact that Colorado hadn't even tried to enforce this law yet really made this a ripe question.
Ripeness is another thing we talked about. So, in other words, you can, for example, if you're just sitting at home and you're like, if I'm transgender and I want to join the military someday, or maybe I want to do that someday, but, I've taken no affirmative steps to do that. I'm just like, on my couch eating Cheetos or whatever. Like, is it ripe for you to sue the military for their particular policies or whatever, right? Like that's what ripeness is supposed to be about. Like, you haven't put yourself into a position where that's going to be an actual, what's called a case or controversy is the language in the Constitution. So I guess here's my take on it. And maybe I'll be a slight sad panda on it. I mean, part of the thing that happened here is Colorado stipulated to the facts. And so I think the court was stuck with whatever, right? The court was going to just assume, Supreme Court is not a fact they're not focused on the facts. I mean, they just take the facts that they're given and they make decisions based off of that. So I think if you're going to find fault with anyone, find fault with the state of Colorado for agreeing to stipulate to that and not doing more due diligence in the front end. I mean, one point I tried to make with the affirmative action cases, I do think that was driven in part by the facts and how try to help people understand how the trial court stuff does impact these Supreme Court decisions. I think here it's the same thing. I mean, I think you could imagine, and the time to fight this, if you're Colorado, would have been on the front end, trying to color sort of the facts a certain way instead of just taking them as given and litigating the pure legal issue. I also will just kind of note, this is a case just like the affirmative action case, in which there's sort of a right-wing creation of a particular, what they consider a favorable set of facts to send up to the Supreme Court. That's done in the left as well. It's been done for a long time, but these impact cases go up to the Supreme Court in part because litigants create these fact patterns that are going to potentially allow the Supreme Court to generate a result. I'm not thrilled with it, but the reality of the situation is, whether it happened this year or next year or the year after, if groups cared enough to create a fact pattern like this to get it before the Supreme Court, so unless, I don't know, a justice retired or died in the very short term, you weren't going to see a different. This wasn't even like a 5-4 decision, so you weren't going to see a different result.
Right. The other implication here is, again, I saw a lot of pundits and people commenting saying, this obliterates all public accommodation laws. People can throw out, Black people from diners again. And, it does not seem to me that the decision goes that far. On its face, at least the way that it's written. What it's really doing, though, it does open a Pandora's box for anyone who's engaging in expressive or creative activity through the course of their business to then make a claim that in order to serve a person, they are being compelled to somehow support a message that they don't agree with. Where that line gets drawn, I mean, I think, serving food to someone at Denny's is not expressive or creative, and I would hope that, a court would not consider it as such. But as you noted, there's a number of different types of commercial activity that is for sure expressive and creative and involves speech. And, that is definitely fair game. And so, again, I think this is going to invite a whole host of litigation as people are denied service in different contexts.
That's right. And one thing I'll just say, too, to preface my comments on this, I'm giving my analysis of a legal decision. Obviously, there's no question that for a lot of LGBT people who are reading this decision, they're like, this is awful. I mean, this is basically the Supreme Court saying it's great. We're okay. It's okay to discriminate against us. And there's no, I can't deny that. So I'm trying to give you a sort of divorced from my own concerns about what sort of society this creates, my analysis of it. But I agree with you that if you just look at this from sort of what the impact will be, is limited by that. Now, you could take it into all sorts of crazy things. There's all sorts of, like you said, there's all sorts of commercial things. I used one example that has been heavily litigated, earlier. But another one, you could say floral arrangements. Like there's an artistic, expressive element to creating floral arrangements. So if I say I don't want to create floral arrangements to gay people, is that or Black people or whoever, is that something the court's going to say it's compelled speech if you try to deny doing that? That's what this opens up.
Right. I mean, and not just as you just mentioned with race. I mean, and this does open the door for discrimination against many groups, not just LGBTQ. You can imagine a cake designer who says, has an interracial couple and just says, well, for me to put, the little figurines at the top of, a Black person and a white person like that, like, I just disagree. I think people should marry in their own race, and I cannot make this cake. I'm guessing that I think they could do that.
I think that's at least that door is open in this decision. That's exactly the point.
Sure.
Cake designing is another one that, in fact, we've had a Supreme Court case out of Colorado similar with that. I think because they're trying to do this as something that they're looking for expressive activity, because they understand Supreme Court has taken a very absolutist view towards the First Amendment, which is very good implications in certain regards. In others, there's a bit much more questionable. And this is one in which I'd say activists are taking advantage of that to try to weaken protection for groups who are being discriminated against.
Right. Okay, so the last one, the debt relief. I don't know if there's much to say except that Biden's plan got scrapped. He's trying again under a different law, the Higher Education Act, which also delegates authority to the Secretary of Education. I'm not familiar with the details, but it sounds like a more incremental and long-term loan forgiveness plan, and I think it will take longer to implement because of various administrative requirements to implement it. So, yeah, I'm not. I don't really. I don't have a strong view on.
I have a hot take. I have some hot takes.
Yeah, give me your hot take.
Okay, here's so hot take number one. This is Biden expected this and wanted it all along, and this is politically
to mobilize the youth vote.
Yeah. I think that this is like Biden's Biden is decided he wanted to do student loans. He realized the Republicans in Congress were always going to be able to block it unless he got rid of the filibuster, which, they didn't have the votes to do, even if he didn't want to do it. But even if he wanted to, they didn't have the votes at the Senate to do it. So, he did this knowing that the chances that the Supreme Court were going to uphold this were very low. I mean, a lot of people who are more experts in this area than you and I, in terms of this, there's scholars who just focus on these delegation issues and so forth, who were very skeptical of this one, and they went forward anyways. Now they're going forward again because in the news, what's the news that young people are getting? Biden's trying to fight to give you your student loan relief, and a bunch of Republicans, whether it's in Congress or the Supreme Court, are against it. So he wins from that perspective. So I think this is going basically just fine from where he stands. And I guess, to me, what I would say, my other takeaway, less of a hot take, but more of a takeaway is, to me, this is just another symptom of the dysfunction that we currently have in the United States Congress and our political system, because we really aren't getting a lot of bipartisan compromise solutions to problems where like people in both parties are rolling up their sleeves and working together. We got a very polarized country. The Republican House is focused on investigating, who Hunter Biden hooked up with 5 years ago or whatever they're concerned about. And so there's, now the executive is trying to do more on their own. And that isn't the way that the Constitution originally was intended. Some of that is because of the way our entire society and government and world is different than what people anticipated in 1776. And that's part of the reason why there's, delegation and, agencies and otherwise that didn't exist at the time of the founding. But part of it is just the fact that where we have a Congress that's not doing what Congress was doing 30 or 40 years ago.
Yeah, I don't disagree.
Okay. See, so I have thoughts about that one, but I think of all of them, that was like the least surprising. I mean, they're all. I thought all of the decisions were kind of along maybe what we might have expected. 303 Creative to me was the most up in the air of the group. Given the composition of this court, I kind of pretty much I think we all expected the outcomes. But I think they're certainly very consequential. And I think the bottom line is for people, elections matter.
I was just about to say, for all of these 4 decisions, we're all 6-3. Three justices who were appointed by Trump.
We always hear every 4 years, oh, this could be the most consequential election of our lifetimes. 2016 almost certainly was.
So, Renato, before we go, yesterday was your birthday.
Yes. So I don't know if I'm like happy about that at this stage. I don't mind birthdays, but boy, it's like I'm not getting to the point where I'm excited about getting years older at this stage. I've just turned 47.
Ooh, happy birthday.
Thank you.
Do you feel like, so I was talking about this with my friend in Italy. I don't feel middle-aged, but I am.
Okay. So I totally feel middle-aged.
You do?
I totally do. Well, I do feel a certain, like, certainly I have a very active life and a lot of vigor. And I in my mind, I'm in my 30s, even though I'm 47.
Right.
Okay. But even 30s are kind of middle-aged, no?
30s are not middle-aged.
Okay. I'm definitely feeling older, though. I think part of it is like, and I'm sure, well, you have this too. It's like you have a house, you have kids, like there's this whole like, I mean, you have responsibilities and yada, yada, yada. Like there's that part of it.
Yeah.
I'm not like partying in the city.
No, we're not partying in the city, and the aches and pains have started, and my vision is starting to go, and like, but it's when I think about how I saw someone who was almost 50 when I was in my 30s, I was like, damn, that is old.
True.
And now, like, that's us.
Yeah, that's true.
And so I'm in denial about that. Like, I'm like, I've convinced myself that 20 and 30-year-olds don't see me that way, but maybe they do. I don't know. I'm just like trying to make myself feel better.
I think they do. I mean, I think they do. I think for me, by the way, growing a beard and because I have like gray hair in my beard, like I aged in terms of how I looked a lot. And I think that changed how people treated me and made me feel older. Like when I had more of a baby face, people treated me like I was in my 30s, even if I was in my 40s, in my mid 40s. But I do feel it a lot because I work with a lot of other lawyers and in my law firm, and I'm typically I'm always the most senior person in any case that I work on. I'm not working for other lawyers. I've got different lawyers who are working on my cases, and it's like talking to these people who just graduated from law school or 5 years out of law school. And it's like, well, 20 years ago, we did things this way when I was practicing law. And it's just having these conversations makes you feel super old because it's like, hey, we didn't, research things this way or do things this way, or the courts used to be this way or that way or whatever. It's just, it's a very different world. And it makes it on a daily basis, it's definitely making me feel my age.
Well, happy birthday to you, and I hope you had a lot of fun celebrating.
We did. Indian food for dinner, actually. That was my choice. Yeah.
Very nice. Absolutely. Very nice.
MSW Media.